Hello and welcome to Absolute Trust Talk. This is our live streaming podcast at Absolute Trust Counsel. I'm Kirsten Howe and I'm here with Madison Gunn today. And we're going to talk about AB trusts, which might not mean anything to you as you're listening to it, but you'll understand it pretty well when we're done. AB trust, do you have one? Do you need one? Madison, I'm going to turn it over to you.
Yeah, thanks. So this episode is just for married people. If you're single, or you might find it interesting, but it's mostly going to be only relevant to married estate plans. But if you're single and looking to mingle, then it might be relevant to you. So might want to pay attention. Today we're going to talk about what we in the biz call AB trusts. It's a common estate planning technique that has, for many couples, overstayed its welcome. Every month, we see these trusts come in the door with new clients. They bring in their trusts from previous attorney, previous lifetime, don't even know what it is, don't know they have one. And when we explain it, they're like, I don't want that. So it's very common, even though it's been like over 10 years since it was a common occurrence, we see them all the time. So we're going to start with the basics so that everyone knows what we're talking about, because I'm sure everyone's like, what are you droning on about right now? Most people who have a written estate plan in California, they have a trust. As we've discussed many a time on this show, just a will requires probate. The trust avoids the probate. So what we're talking about can happen with a will, but it's a little more unusual, and we wouldn't typically advise that. So we're going to assume for this discussion we're talking about a married couple with a joint trust. The trust document for a married couple has to say, at the minimum, what is supposed to happen after one spouse dies. Most people would think, well, it all just goes to the surviving spouse. There's nothing happens, technically speaking. But there are multiple types of trusts that are called different types of trusts based on what happens after that first spouse dies. And that's where this AB trust comes in. There's one critical decision to make when deciding how to leave property to your spouse, and then other decisions will flow out. So it's like that decision tree or decision chart that we go over with our clients, about what happens after the first spouse dies. The first decision is, do I want to control what my spouse does after I die or not? Do I want to reach beyond the grave and control my spouse? So with an AB trust, you can allow your spouse to use your money after you die if they need it, but and your spouse, wait, after your spouse dies, you control who gets it. Sorry. So you can let your spouse spend the money, but when they die, you have already said who gets it after your spouse dies. So if you don't set it up as an AB trust, your spouse can change that estate plan and then change who gets it after they die. So, Kirsten, why is it called an AB trust?
Well, I mean, I don't know. I look old, but I'm not so old that I know I was around when that first was envisioned by somebody. But the basic idea is that married couple has a joint trust, and when one spouse dies, if we're calling it an AB trust, when one spouse dies, it's going to split into two separate trusts. There's going to be the survivor's share, the spouse who didn't die. They have their share, and that's called the survivor's trust. And then there's going to be the deceased spouse share. We call that a bypass trust. You can call it a decedent's trust. You can call it an exemption trust. You see different language around that. But the basic idea is it's going to split into two trusts, survivors and decedents. The survivor's trust remains in the survivor's control. Survivor can do whatever, in my hypothetical head, whatever she wants. I always make the husband die first. And then with the decedent's share, she can do whatever the decedent says she can do. And so that might be she can spend the money or she can only spend the income. There's all kinds of permutations. But the important point is that she cannot change that. The surviving spouse cannot change that. So we have two trusts. One can be changed, one cannot be changed. And why do they call it A, B? I don't know. But, those are the first two letters of the alphabet. But for me, and I didn't make this up either, A stands for above ground and B stands for below ground. Typically, it's the survivor's trust is A, the decedent's trust is B. The decedent, at least in the old days, used to be below ground. Now they're in it, on the mantle. But
I have never heard that before, which is pretty
really,
impressive. Yeah, so this is my learn
oh,
something new every day moment.
a
And
little mnemonic device that
yeah,
somebody
and we
told me.
and we won't scare anybody about the fact that there could be 3 trusts that your trust divides into, but it is something to note to why you would want to update your trust. So why would someone want to control, this is the juicy question. Why would someone want to control what their spouse does with the property after they die?
Well, I mean, there are a variety of reasons and, little sub reasons within each reason, but they might be, I mean, a very obvious reason is it might be a blended family. And so each spouse has children of their own, and each spouse wants to make sure that they take care of their surviving spouse for sure. The vast majority of married couples want to take care of their surviving spouse, but then they want to make sure that when the surviving spouse dies, their share goes to their kids, and they don't want the surviving spouse to be able to go, I won the game. I'm going to leave everything to my kids. So that's a really common reason why you would want to do that. Other things, they might be worried that the surviving spouse will remarry, even if it's not a blended family. Many families end up being blended families eventually because they first spouse dies, then they remarry. So they might want to just say, I want my spouse to be happy, but I don't know who that guy is, and I don't need to leave anything to his children. So they might be worried about remarriage. Another common one is, when the trust splits into two, excuse me, when the trust splits into two trusts, the decedent's share, which we've been calling bypass trust, that's an irrevocable trust. It is protected from the creditors, any potential creditors of the surviving spouse. So if the surviving spouse gets sued and has a judgment against her, the creditors can take her assets. That's how the world works. But the assets in the bypass trust don't legally belong to the surviving spouse. They're available for her use, but they don't legally belong to her. So they're protected from creditors. And that's something to consider. It's not something to just, blow off. It's worth consideration. And I actually had once a surviving spouse who didn't have to set up a bypass trust, but chose to for that reason. And this surviving spouse said to me, I'm really not a very good driver, and I do worry about creditors. And she liked the idea that, this chunk of money was going to be protected no matter how badly she navigated. So
that's pretty self-aware. I like that. It's hard to come by that, I think.
100%
Yeah.
agree. I
I
totally
mean,
agree.
what I normally see is that the wives are worried that that the wives are gonna die first, and the husbands are gonna, have that remarriage and also be vulnerable to a bad
Right.
influence, like a fraudulent marriage or something of that nature. And just to point out, whenever we get those, the husband dies first. So it's
Yeah,
just
at least in our client base,
yeah,
statistically, it's much more likely that the surviving spouse is the wife.
yeah,
Who's worried about the one surviving being preyed upon is also the wife.
yeah, yeah,
So, but that's a legitimate concern because elderly people, men and women,
yeah,
do get preyed upon.
yeah.
Especially by their own family members.
Yes. And the always thing is everyone thinks they can fall back on the elder protection laws, but once the money's gone, you can't get that back usually. So, I mean, the laws are good, but they're not helpful in recovering that estate. So,
Right. It's better to protect the money from going out the door than to rely upon the law to help you grab it back.
Yeah.
That is never good to chase after money.
Yeah. So those are all great and valid reasons, but there is a trade-off. You might like the features of an AB trust, but you might not like certain other features. So what are the cons of the AB trust?
Right. So, like I said, it requires that on the death of the first spouse, we split it into two different trusts. So that involves a certain amount of legal work, accounting work, just to make the split. Assets have to be retitled because it's two different trusts. They each have a name. They each have a taxpayer ID number. Things have to be retitled. So there's, you're going to spend money on lawyers that you wouldn't otherwise spend. And this decedent's trust is an irrevocable trust. Irrevocable trusts are taxpayers. So surviving spouse now has a whole other set of tax returns to do every year when you have this extra B trust. And then the thing that's interesting is the AB trust that we're typically talking about are set up so that when the surviving spouse dies, the assets in that B trust are not going to get a step up in cost basis for income tax purposes. So the kids will inherit these assets that might have been sitting around for years and appreciating in value. And so the kids are going to end up paying capital gains tax on those assets if they sell them. In the US, we are still on the actual capital gains tax system. We don't have deemed step, basis or capital gains. So that's, that could be an issue, especially if one spouse died many years before the other one. There could actually be quite a bit of profit, stuck in those assets that somebody's going to pay taxes on.
Yeah. And that's something that your attorney should discuss when you're talking about the allocation between the two trusts. I mean, depending on the assets of the trust, you might be able to avoid that, but it's got, you've got to work out the trade-off for that.
Well, and you can probably work with your financial advisor too on managing those assets and, taking advantage of, well, let's sell this now and capture some losses to offset the gains. That's what that's what our colleagues in the financial advisory world do, and they do it well. So
yeah. So it gets complicated,
right.
is what we mean to say. So that trade-off of having control comes with complexity and complication, which means expense. Instead, the trust could just leave everything to the surviving spouse with no ongoing irrevocable trust, which is much simpler and easier for the surviving spouse. Nothing changes for them on the day-to-day. But to be clear, that also means what?
Well, of course, it means that legal work that I was talking about that happens with the splitting of the trust into two trusts, that doesn't happen. So you're saving expense, and there's no additional tax return. But so all of that sounds great. The downside is that the surviving spouse now can change the whole estate plan, not just her half. She can change the whole estate plan. And that's something that you have to, we can do it either way. Legally, we can do whatever you want. This is more of a marital issue.
Yeah.
How do you trust your spouse to not change the estate plan?
Yeah. Okay, so having a two trust estate plan might be right for some couples, but not right for others. Why is it that we see so many new clients who have an AB trust and don't want an AB trust, but usually don't even know they had one until they come in with their old trust and we tell them?
Yeah. Now, this is where we're getting to the real meat of this episode, the takeaway that we really want people to, so prior to 2013, this was this very standard way. This is how we set up married couples trust, because it's an estate tax scheme. It's a structure designed to minimize estate tax for the family. When you die and leave assets to your spouse, there's no estate tax because it doesn't count. It's a freebie that we get, and that's right. We should be, helping married couples to take care of each other. Now, prior to 2013, two things. The estate tax exemption could be very low. I mean, I remember there was a time when it was just $1 million, and Madison was probably still in junior high when that was the case. But it wasn't that long ago. It wasn't 175 years ago when I was a new lawyer. It was recently. So $1 million, it used to be, if you had, let's say, a married couple with $2 million and one spouse dies, they leave everything to their spouse, no estate tax. Now the surviving spouse has $2 million estate and she dies, but the exemption is only $1 million. So there's going to be estate tax on that extra $1 million. So what we used to do in the old days is set up an AB trust. The husband, decedent's $1 million goes into a bypass trust, no estate tax, because it was only $1 million and the exemption was $1 million. And then the surviving spouse gets her $1 million. And then when she dies, that B trust it's not part of the estate tax. It's not part of the surviving spouse's taxable estate. Only her $1 million is. So we get his $1 million going to the kids out of the bypass trust, her $1 million going to the kids out of the survivor's trust, no estate tax. So there's a big difference between paying estate tax on $1 million and paying no estate tax. That's a big difference to the family. And we used to have to do that because that was the only way that we could get both exemption amounts preserved for the family and still take care of the surviving spouse. That's what we had to do. It's what we had to do. In 2013, two things changed. First of all, the exemption got bumped up and it has been going up and up and up. Now it's $12.92 million. So none of this conversation is relevant to the vast majority of our clients. Very few of our married couple clients have $25 million or more, which is two exemptions. So that changed. And the big thing that changed is what we call portability. Madison, do you want to talk about portability? I feel like I've been droning on and on.
That's okay. I mean, for portability is similar to the way that the AB trust is set up in that the surviving spouse gets to use some of the exemption. It's that way they can share it between spouses. So if the exemption is, I'm just going to say $12 million per person, and they have the husband dies first and his half of the estate is $6 million, the surviving spouse can file an estate tax exemption to record what he's using of his exemption amount, the $6 million, and then she can transfer the unused portion, the other $6 million, to her. So when she dies, she gets whatever the estate tax exemption is when she dies, plus the extra $6 million from her husband. So they get to use that unused portion of the exemption.
Right. And the unused portion could be all of it. It could be. So if we have the trust that does not split into two trusts, husband dies, his estate is worth $6 million. He leaves it all to his wife, no estate tax. So he didn't use any of his $12 million exemption. Surviving spouse can claim that whole $12 million.
Yeah, because it all transferred to her on that unlimited marital.
Right. Because whatever he didn't use, and he didn't use any of it, if he left it all to his wife, she gets to claim it and then she can use it later when she dies. So she gets her 12 million plus his 12 million. You don't need an AB trust to protect both exemptions. You can do it by just filing that tax return after the first spouse dies.
And for now, with it being, almost 13 million, is that right? Yeah.
Yep.
So we know that the estate tax is going to go down in a few years. So you can use get all that portability now if a spouse dies in the next couple of years. And then if it goes down, you don't really have to worry about it because you have this extra $12-13 million floating around that you get to use.
Right. So, we can effectively do the same thing that we used to use AB trusts to do without using that extra irrevocable trust, if it's still appropriate. It's,
Yeah.
like we said, there are still definitely situations where it's appropriate, but not because of estate tax.
Yeah.
We don't use it for estate tax reasons anymore.
Yeah. And so, like, again, the two trust, the AB structure might be right for some people, but not all. And of course, before the tax laws changed, that's was almost exclusively what we used. And to that event, what should people do to make sure that they have the structure that is right for them? Because as we've kind of alluded to, it's all very situationally and fact specific depending on your marriage and your estate.
Yes. Well, I mean, I think the answer is obvious. You've got to talk to your attorney, and especially if you're a married couple, you have a trust that was written before 2013. There's a strong possibility that you have this AB structure, and you need to talk to your attorney and figure out if it's still the right choice for you, because it might be, but it might not be. And so, always our advice is going to be, you got to talk to your attorney about your situation. You can't determine that by listening to us on a podcast.
Yeah. And like we've seen some weird ones come in that are not a standard formula or a standard instruction on that B trust to how to fund that B trust. So it's really good to have an attorney review that and not just assume. Sometimes we review them and we don't understand what that trust is supposed to say because it's not a normal situation. So looking at it yourself might not be as useful as having an attorney take a look at it. Um,
Right.
and what is that? That is something that they can change. They can get rid of the AB trust if they don't want to.
Oh, sure. Well, while both spouses are alive, all you do is you amend your trust or restate it, whichever way you're going to go. But you can change your revocable trust anytime you want until one spouse dies or
Or
becomes incapacitated. Yeah.
and we see that a lot when people come in for after death or trust administration because there is a little bit of legal work that has to be done after the first spouse passes away. And they didn't know about it, which is 99% of the time. The client doesn't know that they have to split this trust and do a whole allocation agreement or even file an estate tax return. And they're not happy. So,
No, they never, that's one of the two worst conversations we have to have with clients.
yes. And if they don't understand it, it's even worse. So if that trust is supposed to be irrevocable, that means you can't change it. So what are the choices for the clients or individuals who are trying to have discovered that they have an AB trust after they are now widowed or a widower?
Yeah. Yes. And I mean, in common English language usage, irrevocable means you can't change it, but that's not true. Under the probate code, you can always at least try. So there are provisions in the probate code that allow what's called a modification of a trust that is now irrevocable. And so what is involved is a petition to the probate court where we ask the judge, this thing was set up many years ago. Things were different then. The tax laws have changed, and this is really not a good result for this family. Can we please change it? And we do that we do that a lot.
I did it this morning.
You did. That's right.
In court. And that was actually a little bit different of a situation. That was where dad passed away, I don't know, 5-10 years ago, and mom is now incapacitated. And the kids came, and the kids were co-trustees of the trust, only two. And we were like, well, we can't really update the trust because it's supposed to have been split. And so we petitioned the court on behalf of the children, who are the trustees, to modify the trust, and the court granted it this morning. So that
Oh,
happens. The incapacity of the surviving spouse doesn't happen on a regular basis, but those petitions we do on a fairly regular
right.
basis.
That
Yeah.
that one was unusual in that the petitioner was not the surviving spouse
Yeah.
because she didn't have capacity. But so, so these things can be done. It involves a court petition. It can be done. But, going to court is always more expensive than not going to court. So
Yeah.
much better to change it, amend it while you can, while both spouses are still alive.
And frankly, if you haven't updated your trust in 10 years and it's still an AB anyways, your trustees are probably dead. It's probably time to update everything as it
Yeah.
is.
Yes, that's a good point. 10 years is a long time to go without revisiting everything. And so, you should make an appointment with the attorney anyway, because there are probably lots of other things that need to be changed. Okay. Do we want to, are we ready to look and see what kind of questions we have?
Yeah,
Okay.
I think so. I think we've beaten this course.
I think so. Okay. Let's see. I gotta scroll to the top and just make sure I catch them all. I really don't like it when there's a question and I missed it. That's really bad. Okay. So can you do a petition to eliminate the bypass trust if the trust has already been divided?
Yes. We have done that as well. We did that a lot we did it a couple times right before Proposition 19 was going to go into
Oh,
effect
that's right.
because there were properties sitting in the bypass trust that
We wanted to pop them out and give them to the kids now. Yeah.
Yeah, and the important part is that the only reason you're modifying is because of changed circumstances from the taxes, not it's a blended family and
we
taxes
want
are
to disinherit these kids.
Yes.
Yeah.
Yeah.
The judge is not going to sign off on that.
Yeah, the court will scrutinize a little bit more.
Well, and the other, an important thing that we left out, we didn't talk about how the petition is done, but everybody is notified. Everybody knows that you're doing this and they have an opportunity to stand up and say, wait a minute.
Yeah.
If you do this, I'm eliminated. So, it's not going to work.
Even the kids get noticed. The kids, grandkids.
And the grandkids. Yeah. Exactly. Okay. So yes, if it's been already divided, you can do that. And I did one like that quite a few years ago where we weren't trying to get rid of the bypass trust. We were just trying to change its terms so that we would get that step up.
Yeah.
On the second death. We like having the second trust for all of the reasons that we talked about, but we wanted the step up on the second death. So we did it in that case too. Okay. Can you do a petition to modify many years after the first spouse dies? I think you just kind of answered that.
Yeah, you can. It's they do ask for some information like the value of the estate upon this deceased spouse's death. So sometimes that can be a little bit difficult to kind of recreate, but they don't ask for too much. So it's not like you have to come up with bank statements for a savings and loan or anything like that. It's just, it's not too bad, but it does just require a little bit more cooperation from the client than would normally be.
Yeah. The passage of time doesn't make things easier for sure, but the main focus is on what do we have right now? If we undo this split, is the surviving spouse going to have a taxable estate? No, Your Honor. That's kind of what they're concerned about. So, okay. I don't see any other. Well, wait a second. I better scroll all the way back down to the bottom. Just make sure I haven't missed anybody. Okay. I don't see any other questions. Speak now or forever hold your peace. Madison, you want to finish us up? Or
yeah, the big takeaway is if your trust is older, it's time to take a look at it. Make sure you're not going to have any surprises. It's bad enough for someone to get widowed and then to have a big legal, fiasco on their hands. That's how it's treated. If you can avoid it, as are the majority of our topics of conversation, if you can avoid the crisis, we much prefer a planning call to a crisis call. It's a lot easier to deal with. It's a lot less stressful. So it's time to take a look at your trust and make sure it's it's good to go, particularly if you're worried about, one of the spouses losing capacity or anything of that nature. We want to get that looked at as soon as possible.
Very good. All right. Thank you all for joining us here today. I hope you got a lot out of it, or at least a couple of nuggets, and it will inspire you to be proactive, do something before it's too late, and tell your friends. Thanks for being here. We look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.